Your Lordship, the first termination was under the Rule 11, Subclause 4 of the Service Rule of Lower Judicial Services. And that time they have made me as I was a probationer. So they terminated under the Rule 11, Subclause 4. And when the Honorable single bench of this High Court has decided to reinstate me, that time the court has given me a reinstatement in my formal post with continuity of service and with notional seniority.
By no order, your services have been regularized till your reinstatement.
Your Lordship.
Because as and when you have been terminated,
Your
your
Lordship.
period of service was stopped.
Your Lordship.
You may continue after your reinstatement. Your probation period may continue after your reinstatement. एक महीने में कैसे? How can you assess her performance? So the decision taken by the standing committee was still alive.
Still alive.
But after the reinstatement, how can you consider the earlier report of this?
See the ACR, which they have communicated me that ACR is of year 2015 and 16. That was communicated to me post my termination 2 months after my first termination in 2017. And that ACR reads
When it has been communicated?
10th April 2017. And I was terminated on 9th February 2017.
After your termination.
After 2 months of termination, and that ACR is of 15-16. And that should have communicated me before 15th August as per the regulation. See, the confidential rules. It clearly says that every ACR for the year should be communicated to the concerned officer on or before 15th August. So why they have not communicated me that ACR? And they have full right. I am their employee. They are superior officers. I am nobody else. They could have terminated before 3 years. Why they have waited for 3 years?
हाँ 2017 में ना 17 में टर्मिनेशन था.
तो वो उस समय बर्मन का जजमेंट नहीं आया.
बर्मन जजमेंट कम इन द ईयर 2023.
So
कहाँ गए? Yes, Mr.
It has to be heard finally. It has to be heard finally.
Ready?
Yes, Lordship.
कितना टाइम लगेगा? टाइम सेकेंड राउंड एप्लीकेशन ना. फर्स्ट राउंड में क्या हुआ था? पिटिशन अलाउ हुआ था.
Yes, Lordship.
अलाउ हुआ था. She has been reinstated.
She was reinstated. She was reinstated, and thereafter she was.
So on the ground on which she was earlier removed or terminated was not in the present. The ground which is available in the present petition
Was taken.
Present petition was not taken in the earlier round.
Was taken.
Your Lordship, the first termination was under the Rule 11, Subclause 4 of the Service Rule of Lower Judicial Services. And that time they have made me as I was a probationer. So they terminated under the Rule 11, Subclause 4. And when the Honorable single bench of this High Court has decided to reinstate me, that time the court has given me a reinstatement in my formal post with continuity of service and with notional seniority.
Which notional seniority?
With notional seniority, and that is in Annexure R.
At the time when you earlier terminated, you were on probation.
That time that time they were.
You were on probation.
Yes,
So
Lord,
at the
Lordship.
time when you have been reinstated,
Yes,
you have
Lordship.
been reinstated on probation or on permanent capacity.
No, Lordship.
Probation.
No, Lordship. The appointment order does not say that I am again reinstated as a
But
probationer.
at the time when you have been terminated, you are on probation.
Your Lordship.
by no order your services have been regularized till your reinstatement,
Your Lordship.
because as and when you have been terminated,
Your
your
Lordship.
period of service was stopped.
Your Lordship.
You may continue after your reinstatement. Your probation period may continue after your reinstatement.
Your Lordship, that's why there are rules that I wanted to make it clear. And the first order, when regarding my reinstatement, the order itself says that I have been reinstated with notional seniority and with continuity of service, not as a probationer. And the
नहीं,
appointment.
notional seniority अलग चीज है. Notional seniority अलग चीज है, क्योंकि सीनियरिटी आपकी वहीं फिक्स होगी जहां पर आप अपॉइंट हुए हैं.
Your Lordship, and there are some more issues also. Like the last time, the honorable single judge, honorable single bench has said that the standing committee does not have power to recommend the termination. And then the next time they have again says that in 2023 November 2023 they have amended the rule of. Chhattisgarh High Court's rules they have amended, and then they again inserted one subclause there, and they says that now the standing committee has the power to recommend.
Because
So again,
the amendment was prior to your subsequent
the
termination.
second termination,
That
was
is
the
prior to your
Yes,
subsequent
Your
termination.
Lordship, invoking that rule, they have again terminated me, but that rule is still barred the recommendation for termination. Your Lordship.
So have you changed that rules?
Your Lordship, that rule is still bars.
नहीं, whether that rules
Your
have been
Lordship,
challenged?
this rule also does not give power to recommend the termination of a person, of a judicial officer. Your Lordship. And the rule is, kindly see the rules, Your Lordship. As I have mentioned in my writ petition,
Where is your earlier termination order?
it's annexure P50 P11, Your Lordship, page
Page?
number 43.
Page
43.
43.
P11, page 43.
What was the charges?
Charges against me, Lordship.
Yes.
They have taken the ACRs and work assessment.
She was on probation. Probation was determined. It was
Her services were not found satisfactory
yes.
during the probation period. Looking to her work efficiency or to
after
be
evaluating the entire. Therefore, the order did not mention about any allegation or anything. It was a very innocuous order. saying
obviously वो recommendation पे the state government has issued that order. And, what is the allegation at present?
that- Lord, again, her services
Same.
were
Same.
Your Lordship,
When you have been reinstated?
in by the order dated 28th November 2024, and I have joined on 4th December 2024.
4/12.
4/12/24.
Huh.
24. And I have again terminated on 15th January 2025.
15/1/25.
25. Yes, Lordship.
Yes, Mr.
Your Lordship,
एक महीने में कैसे how can you assess her performance?
No, वो तो पुराना because the first
पुराना
order
तो
of
चला
termination- नहीं गया उसमें my lord, in fact that
Is there any
something-
liberty granted in your favor?
yes my lord, in fact what had happened is I mean I was waiting that she might
Yes, I will.
In the first judgment,
Hmm.
though the first judgment she has not annexed it, I had filed it along with my reply.
Hmm.
In my reply, my lord,
Hmm.
if my lord may have a look at annexure A1,
Hmm.
this is the order, my lord.
R21
A1.
in your reply.
Oh, I'm sorry. R2. R21.
R21 na?
My lord. R21.
Hmm.
Page number 17.
Huh.
Now, this is the judgment, my lord, rendered by the Honorable Single Judge,
Hmm.
against which we preferred a writ appeal, it was rejected. Against which she also preferred a writ appeal, the writ appeal was also rejected.
Hmm.
Against which she had preferred an SLP, the SLP also rejected.
So this order has been affirmed up to
Affirmed.
the Honorable Supreme Court.
Up to the
No, Your Lordship, the SLP, that's the misleading part of the opponent counsel.
yeah.
Actually, I have not preferred SLP, that is rejected by the Supreme Court. I have filed one writ petition under
So
Article
your writ
32.
appeal was dismissed.
No, it was not dismissed. It was like orally the Supreme Court directed me to withdraw it because this High Court, the original jurisdiction lies between with this court.
The fact
So,
remains that
SLP is different. I have filed 3 cases, 2 SLPs and 1 writ petition. 1 writ petition against my termination order.
this one
This-
2206 ये जो R2Y1 है,
No, against this I have filed already 1 SLP and that is
before-
pending.
नहीं,
Supreme Court.
देखिए, you have earlier filed a single writ petition 2206 2017.
That is against my first termination order.
The first termination.
First termination
This
against
has been challenged in writ appeals
in writ appeal.
by you also and by the
In the both
High
the
Court
parties.
also.
Yes, sir. Yes, sir.
What is the number of that? What is the order passed in that writ appeals?
That was the order of the single bench was affirmed by the DB.
By reasoned order के withdrawing या कुछ ऐसा कुछ?
No, nothing.
by reasoned order.
Reasoned order. Where is that order?
My lord, I was referring to the first order, my lord, annexure R21.
R21.
R21, page number 17.
हाँ.
Page number 17, my lord. Page number 17.
हाँ.
Now, my lord, the relevant part, if my lord may just have a look at para 35.
Para 35.
Para 35. Para 35. Further submission of the petitioner. Further submission of the petitioner that ACR of the petitioner, which was graded D, has been communicated after the order so and so of termination was passed, and the same has lost its significance in view of the law laid down by the Honorable Supreme Court in Devdutt and Sukhdev Singh, also deserves to be rejected by this, as the standing committee has assessed the overall performance of the petitioner. Thereafter, impugned order has been passed, which does not vitiate the decision of the standing committee not to confirm the petitioner on the count of non-communication of the ACR for the year 2015-16. So, my lord, the grounds of challenge which the petitioner has raised here, my lord, in the
ठीक है.
present petition.
Now, if the standing committee does not confirm her
My lord,
on the post, whether is there any provision to extend the probation period?
yes, there is a provision, though. And then, my lord,
It may be extended. The
It may be
probation period may be extended.
and then thereafter, my lord, she was already extended.
Huh.
The provision period was extended. After she was reinstated, the standing committee again took up the matter. It was placed before it. They considered
After reinstatement.
after reinstatement. And thereafter, there was this recommendation, my lord, wherein again they recommended to the extent that her services may not be confirmed.
नहीं, ठीक है. It does not vitiate the decision of the standing committee not to confirm the petitioner on the count of non-communication of ACR for the year 2015-16.
My lord, ठीक है.
So the decision taken by the standing committee was still alive,
Still alive.
but after the reinstatement,
My lord.
how can you
They
consider the earlier report of this?
No, they did not consider the earlier report. They applied their mind afresh. The first writ petition was allowed, my
They
lord.
applied their mind afresh
Afresh.
on the basis of the material available at
Okay,
the earlier
earlier,
petition.
earlier.
The
Yes,
earlier
Lord,
petition would
Your
remain the
Lordship.
same because her work discharged during her
Because
period
you
of
have
probation.
already applied your mind,
They had already
you have
applied.
already terminated her.
My lord,
That termination order was set aside.
That order was set aside on technical reasons.
Huh.
The reason was that the standing committee did not have jurisdiction. But then, while saying so, the Honorable Single Judge again addressed that whether the decision was otherwise correct or not on merits. So the honorable single judge said that on merits it is correct, but then since there is a technical this thing that the jurisdiction was not there, it was set aside. Nonetheless,
क्योंकि
the matter was referred to them again. They took up the entire work discharged by her during the period of probation. Work discharged by her would remain the same because she had already discharged her work during the period of her
लेकिन
probation.
उस पे तो आप ऑलरेडी डिसीजन ले चुके हैं ना पहले.
मेरे पास वही मटेरियल रहेगा सर, क्योंकि इन्होंने जो काम किया
जब रीइंस्टेटमेंट होके आए तो व्हाट इज देयर टू असेस?
अगेन द एंटायर सर्विस रिकॉर्ड में
The old service record, your
the
lordship.
old service record ही तो रहेगा आपका प्रोबेशन
इसीलिए तो क्योंकि उस पे तो वो
अब नया सर्विस रिकॉर्ड तो सर आएगा नहीं ना, क्योंकि
उस पे तो लिटिगेशन करके आ गई ना, वापस रीइंस्टेट हो गई.
वो इसीलिए रीइंस्टेट हुई बिकॉज द स्टैंडिंग कमिटी डिड नॉट हैव जुरिसडिक्शन. कोर्ट ने कहा कि आप प्रॉपर्ली एग्जामिन करिए, प्रॉपर्ली एग्जामिन करिए. इफ लॉर्ड में हैव अ लुक लॉर्ड, द ऑर्डर
does it not prejudice the ultimate outcome of that decision?
It will not move. It will not move because the work discharged by her, my lord, would remain the same. My lord, may I kindly have a look at page 57, my lord? Because as a probationer, she had already worked.
वो ठीक है.
It is her work जो उन्होंने probationer के तौर पे किया, which is to be assessed. Page number 57, my lord. Page number para 38. Accordingly, the writ petition is allowed in part reinstating the petitioner on a formal post that is so and so with continuity of service but without back wages, reserving liberty to the respondents to proceed further in accordance with law if they so desire. And then this order, my lord, was challenged. The writ appeal order is there, my lord. The operative portion of the writ appeals order, my lord. Page number 79.
Page number
79.
This is the order passed in writ appeal.
Writ appeal. Page number 79, para 23.
Both these writ appeals jointly decided.
Both
Both
jointly
yes,
dismissed. Para 23. In view of the above findings recorded by the learned single judge, petitioner, except relief of back wages, has not challenged other findings recorded in impugned order, and further considering the writ petition was allowed on technical ground, this court is of the considered opinion that there is no substance in writ appeal. The same is liable to be and is hereby dismissed.
So this order has been challenged in the SLP.
Before the Supreme Court, it is still pending, your lordship. This SLP
This
is
order?
still, yes, lordship. This pending. It is pending. And your lordship, this time what they have considered for termination of my service is, it is on annexure P22 at page 62.
नहीं तो फिर जब ये ऑर्डर ऑनरेबल सुप्रीम कोर्ट में पेंडिंग है तब तो फिर कैसे फिर इसमें होगा?
Your lordship, but the Supreme Court has given direction to file a matter here all against this second termination because the cause of action is again there is a new cause of action because
now you have to if there is such a direction,
yes,
now you have to apprise that की subsequent termination है, you have to make application before the honorable Supreme Court के साथ.
No, your lordship,
इसमें
the
करना
writ
पड़ेगा.
petition, can you please see the annexure P1
P1
at page 29.
page
29. Your lordship, the first para says Mr. Such and such on behalf of the petitioner seek to withdraw this present writ petition for approaching the High Court by filing writ petition under Article 226 of the Constitution. Permission granted, writ petition is disposed of as withdrawn. Upon filing such petition, we request the High Court to take up and dispose of the writ petition as expeditiously as possible.
But ये तो withdraw हो गया ना?
This is the writ petition.
Before the honorable
Supreme Court, and that honorable Supreme Court
against
is
the order dated
the second termination order, your lordship.
ये वाला जो
Second term अभी जो हुआ जो
नहीं अभी जो termination हुआ
जी उसके
against
अगेंस्ट में
आप direct
32
Supreme
में
Court चले गए.
सुप्रीम कोर्ट गया.
direct Supreme Court,
Direct
you have directly
Supreme Court
approached
गए.
to before the honorable Supreme Court. You have withdrawn your
petition, writ petition, and then it was directed orally that I have
so
to.
have you apprised the honorable Supreme Court that
Your lordship, the SLP is already pending there.
उसमें क्यों नहीं आप
All three cases were taken
SLP
together.
आपकी pending है
So together there is another.
नहीं, वो जो अभी जो अर्लियर लिटिगेशन के उसमें
Your
SLP
Lordship,
पेंडिंग है,
yes, Lordship.
उसमें आपने क्यों नहीं एप्लीकेशन लगाया?
Your Lordship, because this was the new cause of action. The Supreme Court directed that it is a new cause of action. So we cannot direct entertain. You just go there.
Where is that direction?
That is in P14.
P?
Just a minute. P14, Your Lordship.
P14?
P14. Page 48.
ये तो नोटिस इशू किया.
Yes, Lordship. This is pending. This both all the three cases were taken together on the same day, and the order date is the same, Lordship. For this and that is both of is of 15th.
कंडोनेशन ऑफ डिले पे नोटिस किया ना.
Condonation of delay for this SLP.
हाँ.
And this is still in that case, I think party has appeared and there is a direction to file the reply. There are two more cases, Your Lordship.
Before the Honorable Supreme Court.
Before Honorable Supreme, two more SLPs. One is against my RTI application under which I
वो
have.
तो अलग है.
Yes,
RTI का
Lordship.
अलग है.
This and this second writ appeal 362 and 363. The both have been taken by the Supreme Court, but the writ petition against my termination
वो
order.
जो 363/24 है रिट अपील.
Writ appeal.
उसमें आपके खिलाफ क्या डायरेक्शन हुआ था?
मेरे बैक वेजेस मुझे डिनाई कर दिया था.
अच्छा, तो वो भी चलिए अलग मैटर है. अभी तो रीइंस्टेटमेंट का मैटर है.
जी.
362
तो 362 का SLP जो है वो एक सुप्रीम कोर्ट में है. एक RTI वाला जो इन्होंने मेरा RTI मैंने ACR मांगा था वो रिजेक्ट किया, वो भी सुप्रीम कोर्ट में पेंडिंग है. पर जो सेकंड टर्मिनेशन के अगेंस्ट में जो वो है पिटीशन, उनको उन्होंने बोला कि हाई कोर्ट के पास
362/24 है
जी
बिफोर ऑनरेबल सुप्रीम कोर्ट.
योर लॉर्डशिप.
इसमें क्या इशू है?
इसमें अभी डायरेक्शन हो चुका है अपीयरेंस का, फिर अब जवाब के लिए लग चुका है.
किसके अगेंस्ट में गई हैं आप? कौन से डायरेक्शन के अगेंस्ट में गई हैं?
ऑर्डर के अगेंस्ट में गई हूँ. ये 20
में तो रीइंस्टेटमेंट का ऑर्डर हुआ
जी. ये 20/9/2024 को जो DB का ऑर्डर है उसके अगेंस्ट में SLP है.
तो DB ने तो डिसमिस किया ना आपकी
जी
रिट अपील.
जी. बैक वेजेस फिर से डिनाई
बैक
कर दिया
वेजेस का.
जी.
तो 363 में क्या इशू है?
362 और 362 मैंने फाइल किया था, अपील किया था, और 363
देखिए,
इनने अपील किया था.
ट्रायल मतलब लर्नेड सिंगल जज ने
जी
आपको रीइंस्टेटमेंट करने का ऑर्डर किया,
जी
बैक वेजेस नहीं दिलाया.
जी.
ठीक, आपने रिट अपील फाइल किया, बैक वेजेस दिलाया जाए.
बैक वेजेस दिलाया
हाई कोर्ट ने अपील किया कि इनको रीइंस्टेट नहीं किया जा
नहीं किया
सकता.
जाए. जी
बोथ दीज अपील्स वर डिसमिस्ड.
जी.
You have again approached before the Honorable
Because
Supreme
the
Court.
order was concurrent, your lordship. Both the appeal was decided
हाँ, हाँ.
concurrently.
तो आपको जो हाई कोर्ट की अपील डिसमिस हुई
जी.
उनसे तो कोई ग्रीवांस नहीं होना चाहिए.
Your lordship, because both the orders are same. Concurrent order was in the concurrent order, both the appeals was decided.
Virtually you are aggrieved by the order of non-granting of the back wages.
Your lordship, because the judgment was passed on both the appeal together on 20th September 2024. That's why this appeal is I have to file appeal against both the order, because the order was concurrent. एक साथ डिसाइड कर दिया DB ने दोनों को.
नहीं, लेकिन जो इनकी अपील है आपको तो एग्रीवांस उसी से होना चाहिए ना. यस मिस्टर,
उसी से होना,
क्योंकि आपका ऑर्डर जो है रीइंस्टेटमेंट का वो अफर्म हो गया ना.
और एक्चुअली
ऑर्डर अफर्म हो गया.
अगेंस्ट ऑर्डर मैंने SLP फाइल किया है, और ऑर्डर जो है वो 20 सितंबर का है, और वो 20 सितंबर के जो ऑर्डर और जजमेंट है लॉर्डशिप, उसमें दोनों को डील किए हैं. क्योंकि एक ही ऑर्डर से दो अपील फाइल हुई थी.
हाँ
जी, और दोनों अपील को एक साथ
आपको
डिसाइड
जो
कर
रिलीफ मिला है रीइंस्टेटमेंट का
जी,
उसको तो नहीं चैलेंज करेंगे ना.
उसको मैंने चैलेंज नहीं किया. मैंने अपना बैक वेजेस के लिए किया जो उन्होंने डिनाई किया, और लेकिन दोनों ऑर्डर को एक साथ क्लब कर दिया, दोनों अपील को एक साथ डिसाइड कर दिया ऑनरेबल डीबी ने। योर लॉर्डशिप, और सेकंड टर्मिनेशन जब इन्होंने मेरा डिसाइड किया तो उस समय जो इन्होंने ऑर्डर्स लिए योर लॉर्डशिप, तो एनेक्सर P22, kindly see annexure P22 at page 62. Last para, your lordship, the standing committee considering the overall performance, entire service records and ACRs, including the assessment chart of Kumari Akanksha Bhajaj, found that she is not fit for confirmation in service. Therefore, it is resolved to recommend termination of her service under sub rule 4 of rule 11 of the Chhattisgarh lower judicial. Your lordship, यहाँ पर ये सारा ACR लिए हैं. Your lordship, ACR, kindly see the ACR which they have communicated me, that ACR is of year 2015 and 16. That was communicated to me post my termination 2 months after my first termination in 2017. And that ACR reads,
when it has been communicated?
10th April 2017. And I was terminated on 9th February 2017.
After your termination?
After 2 months of termination, and that ACR is of 15-16. And that should have communicated me before 15th August as per the regulation of confidential rules. And the ACR, what they communicated, and now they, on the basis of that ACR, they have again terminated me on this time. That time they said, we have not communicated you with that ACR, that's why we are not taking consideration of that ACR. Now they are taking that ACR into consideration, and they are saying that your ACR is not good. And they have not given me an opportunity to represent against such adverse remarks. That I will show you. That is in
yes, Mr.
Your lordship, P12,
P12,
page number 45. This ACR was communicated me after my termination, 2 months after my termination, and this ACR reads the last at 46 page number, the last sentence. That is the review remark given by the Honorable Portfolio Judge, which says that she would not be able to discharge any other job. And this was commented, and there are many adverse remarks are there, and this was communicated me after my termination. Until this time, I have never given opportunity to represent against this ACR. And another thing is, your lordship, they have also taken the ACR, when you see, I have applied for RTI. Then what are the documents which the standing committee has taken for consideration of my confirmation? Then they have provided me some documents, and at page 83, annexure 22. Here they taken consideration of my ACR for 2015-16 and 2016-17. And before writing the ACR for 2016-17, I was already terminated. And when we go to the rules says there are the 6 parts of every ACR. And the first 2 parts, part 2 and part 1 and part 2, shall be filled by the person, like the officer. And I have not even given a chance to fill the part 1 and part 2, and they have wrote my whole ACR. And now they are taking consideration. They are giving me D, and not even giving a opportunity to represent against those ACRs. And they are saying we are just taking all the things. Not even giving me opportunity to represent against what they are writing in behind my back. And your lordship, when we go through the rules, the rule itself says the standing committee does not have power to recommend a termination. It's the only High Court. And the rule itself say
Where is that rule?
The rule, this is the service rule, Chhattisgarh Lower Judicial Service Recruitment Condition and Service Rule, where you can see the rule 11. If the rule 3 says, Lordship, the High Court may at any time before
11.3.
Rule 3, 11.3, probation, because the probation term is defined under this rule. So 11.3 says the High Court may at any time before the completion of probation period extend the period of probation, but the total period of probation shall not exceed 3 years. And then the next rule says, Rule 4 says the High Court may at any time before the completion of probation period recommend the termination of service of civil judge appointed under such and such category.
The High Court.
The High Court. Here also it says High Court. And the Rule 5 says on completion of probation, a probationer shall be confirmed in the service or post. The period, the 3 years period that I have already completed.
The High Court may at any time before the completion of period of probation.
Before completion of probation period, Lordship. And the 3 says it shall not exceed 3 years.
If it has been extended,
the total period of probation is 3 years.
it's 2 years.
Your
Before the
Lordship,
expiring probation extend the period of probation, but total period of probation shall not be exceed 3
total,
years.
yes,
So
Lordship,
initial period of probation was
2 years. 2 years.
It can be extended
Till 3 years.
till 3 years.
But total period cannot be extended
It
beyond.
shall not be.
It shall
may
not
be. It may be.
It shall not be, Your Lordship.
It may be extended up to 3 years.
3 years. Up to 3 years. They have already
The
extended.
maximum period of 3 years.
They have already extended my termination, probation once.
Probation
18th March 2016, they have already extended my termination with other 9 judicial officers. But it says the total period shall not exceed 3 years. And the 5 says on completion of probation, automatically, like if they are not terminating my service before 3 years, they can terminate me. But they would have not. But they have not terminated me. But they cannot terminate it beyond going that period, and they say that I am a probationer. Like what they did this time.
when your 3 years have been completed.
27 December 2016.
27/12/2016.
2016.
ये 3 years completed.
Yes, Lordship.
So after 27/12/2016,
They have
you have
terminated
been
for
deemed
the
to be
first time.
regularized in your services.
Yes, Lordship. According to Rule 5. Because it does not say that any specific order or test or any act would be done by the concerned judicial officer or by the appointee. It does not say that. Because when we see there is a specific landmark judgment by the Honorable Supreme Court in the High Court of Madhya Pradesh through Registrar and others versus Satyanarayan Jhawar. This case is also concerned with the judicial officer. In that case, the para 11.
वो जजमेंट कौन सा है?
State of
नहीं, citation क्या है?
citation is 2001-7 SCC 161.
161. 161. What it says?
In the para 11, Your Lordship.
Yes.
The question of deemed conformation in service jurisprudence, which is dependent upon language of the relevant service rules, has been subject matter of consideration before the court, times without number in various decisions, and there are 3 lines of cases on this point. 1. Line of cases where in the service rules or the letter of appointment a period of probation is specified and power to extend the same is also conferred upon the authority without prescribing any maximum period of probation. And if the officer is continued beyond the prescribed or extended period, he cannot be deemed to be confirmed. In such cases, there is no bar against termination at any point of time after expiry of the period of probation. other line of case is that where while there is a provision in the rules for initial probation and extension thereof, a maximum period for such extension is also provided beyond which it is not permissible to extend probation. The interference in such cases is that officer concerned is deemed to have been confirmed upon expiry of the maximum period of probation in case before its expiry order of termination has not been passed. The third line is the last line of
all these issues have been considered or not in first round of litigation.
जरूरत ही नहीं थी उस समय तो उनका पीरियड ऑफ कंफर्मेशन वो हुआ ही नहीं था बिकॉज हुआ ये कि इनका जो एक्सटेंशन था she was not confirmed. That is the reason why she is harping upon the fact that when she was reinstated, she was given notional continuity of seniority.
And therefore it comes
And
to deemed
then she raises this argument that I deemed confirmation would step in.
Yes.
Your Lordship, the second line,
And when you have been earlier terminated?
9th February 2017.
नहीं 15/1/25 नहीं अच्छा subsequent डाला फर्स्ट वाला
9 फरवरी 2017.
9/2/2017
2017.
तो Mr. Das on 9/2/2017 she has already completed 3 years.
She was
On 27/12/2016 she completed 3 years of her service. The extended period, including the extended period of probation. On 28/12/2016 she deemed to be confirmed.
But yes, but then this was not.
That was issue. That point was taken by me, but it was not decided by the honorable bench.
Even otherwise, she was deemed to be confirmed on 28/12/2016
But
onwards.
we are disputing that there is no deemed confirmation of judicial officers because then this very judgment deals with it.
But your rule says, Rule 5, 11.5.
11.5, yes. 11.5
What
says
she,
that on successful
recently-
completion of probation, a probation shall be confirmed in the service or post. Meaning thereby there has to be an act of confirmation.
No, Your Lordship, it does not say that. It does not say. It says automatically.
A probationer shall be confirmed in the service or post to which he has been appointed, and if no permanent post is available, a certificate shall
तो
be
ये
issued.
condition तो है नहीं,
Second
because you have
condition
the
है।
permanent post.
हाँ नहीं है ना मैं तो ये कह रहा हूँ I am harping upon the fact that a probationer shall be confirmed in the service, and then Lord, a person appointed on probation 6, I am referring to 6 Lord, on probation
Shall continue
as such terminated. I'm sorry.
until termination or
Yes.
confirmed.
Until terminated or confirmed.
Terminated under Rule 4, confirmed under 5.
Or confirmed under sub rule 4 or sub rule 5 as the case may be.
So it doesn't say कि if there is no order, specific order
Yes,
with
Lord.
respect to her confirmation,
Well,
she can be treated as the probationer.
Yeah, but that is what the argument is, that this shall, where they have referred to in sub rule 1 shall, that shall may be read as may. Because it will not be read as shall, given a literal meaning.
No, there is substantial
That is
difference in
the-
shall and may.
No, that is the argument that the petitioner is raising, that this has to be read as shall, which we say because when we read the holistically the entire provision.
Because the word used as shall, the probationer shall be confirmed in the service.
Yes,
Why?
meaning thereby there has to be an act of confirmation on successful
No,
completion.
if no order has been passed, then
That is what this judgment deals with it. This judgment, there are three situations, my lord, that the judgment refers
2001 7
One,
SCC.
to. So for the first line, my lord,
तो
it says
डीम्ड कंफर्मेशन बोल रहे हैं ना
इनका कहना है कि डीम्ड कंफर्मेशन बिकॉज पीरियड मैक्सिमम पीरियड दिया हुआ है, मैक्सिमम पीरियड हो गया, देयर इज नथिंग एल्स टू बी डन एंड देयरफॉर अ डीम्ड कंफर्मेशन. देन देयर इज अ थर्ड लाइन ऑफ जजमेंट. द लास्ट लाइन ऑफ केसेस इज वेयर my lord, find what पैरा 13 में ही,
पैरा 13
पैरा 13 में लास्ट फोर लाइंस.
नहीं, SCC का नहीं, वो 11 योर लॉर्डशिप 11 पैरा 11,
पैरा 11
वो 11 है.
Para 11 and last 5 lines. The last line of cases.
the last line of cases
Cases is where, though under the rule maximum period of probation is prescribed, but the same requires a specific act on the part of the employer by issuing an order of confirmation and of passing a test for the purposes of confirmation. In such cases, even if the maximum period of probation has expired and neither any order of confirmation has been passed or has the person concerned passed the requisite test, he cannot be deemed to have been confirmed merely because the said period has expired. Now, this has been subsequently, my lord, in later paras explain. Para 15, my lord. In case of Kedarnath Bhal,
Yes.
in the case of Kedarnath Bhal versus State of Punjab, a person applied for the post and he was appointed on a post which belongs to Punjab Provisional Service Class 1, and the post was temporarily sanctioned up to so and so and was likely to continue thereafter. The post was extended from time to time. When the same was discontinued, and on the discontinuance, the appellant was reverted to his original post. When a writ application was filed before the High Court challenging the order of reversion, the same was dismissed and dismissal was upheld by the division bench of the High Court in appeal, as well as this court on further appeal being brought to this court. While dismissing the appeal, the court laid down the law thus as so and so. The law on the point is now well set. Where a person is appointed as a probationer in any post and a period of probation is specified, it does not follow that at the end of the said specified period of probation, he obtains confirmation automatically, even if no order is passed in that behalf, unless the terms of the appointment clearly indicate that confirmation would be automatically follow at the end of the specified period, or there is a specific service rule to that effect. The expiration of the probationary period does not necessarily lead to confirmation. At the end of the period of probation, an order of confirming the officer is required to be passed, and if no such order is passed and he is not reverted to the substantive post, the result merely is that he continues in his post as a probationer. The terms of appointment do not show that the appellant would be automatically confirmed on the expiry of the first 6 months of probation, nor is there any rule brought to our notice which has the effect of confirming him to the post after expiry of the period of probation. The position of the appellant, therefore, till the abolition of the post so and so was that he continued so and so. So we are laying stress on this, my lord, because here the rule says her appointment order, my lord, may have a look. The order of appointment is annexure P3, my lord, page 32.
First appointment ki subsequent appointment?
First
32.
30. Annexure P3, page 30. Well, would have
Yes.
in exercise of the powers conferred by Article 234 of the Constitution of India, read with sub rule 1 of Rule 5 of the Chhattisgarh Lower Judicial Service Recruitment and Conditions of Service Rules 2006, and on the recommendation of the High Court of Chhattisgarh, the state government hereby appoints so and so on the post of civil judge entry level in the junior pay scale of so and so, under clause A of sub rule 1 of Rule 3 of the Chhattisgarh Lower Judicial Service Recruitment and Conditions of Service
2
Rule
years
2006,
or till further orders.
or till further orders. So this is what the judgment refers, my lord. The clause has to be there under the order of appointment. It simply says or until further orders from the date she assumes charge of her office. So until there is this order of confirmation, this whole concept, my lord, of deemed confirmation, that will not step in.
Yes, madam.
Your Lordship, but the Rule 5, they says that in this Satyanarayan case, actually it was the old case in which there was a Rule 24 of judicial services. In that rule, they says that there are some examination for the confirmation. That rule specifically says that. But here, as the Rule 5, it doesn't says that any act or there should be any order of confirmation. It simply says that on completion of probation, and we cannot say that the 6 we cannot read 6 alone, and it says because till the order of confirmation or the termination is not passed, they are probationer.
Das,
It
what
means
does it
there
means?
for the lifetime they will
Mr.
be a
Das,
probationer.
what does it means? Unsuccessfully completion. Rule 5.
Rule
Sub
5.
5.
Rule
11
5.
sub rule 5.
Successful.
Unsuccessfully completion of probation.
But this successful is not automatic. और ऐसा नहीं है कि किसी तरह मरते बचते बस में पीरियड पार करना है मेरे को, नहीं. It is successful completion of probation.
Your Lordship.
एक मिनट.
So there has to be this objective consideration. केवल आपको
So
time
there
pass
is a
नहीं
rider. There is a rider.
There is a rider.
कि unless she has completed the probation period successfully, he should not be.
Therefore, my lord, when I read this Rule 5, my lord, I'll read it again. on successfully completion of probation, a probationer shall be confirmed in the service. So there is a conscious act of confirmation. मैं केवल टाइम पास करके किसी तरह ये पीरियड निकाल दूं और then I argue that automatic confirmation, what is going to happen to the judicial services?
Your Lordship,
Deemed confirmation and presumption that I am a good officer and therefore confirmed. No successful, no order of confirmation. बस क्योंकि मैंने समय पार कर लिया.
Yes, madam.
Your Lordship, they have time till 3 years. They could have terminated me before 3 years also.
नहीं,
Why they were waiting for
they are waiting for your upgradation.
upgradation without giving me an opportunity to represent against my adverse remarks also?
So if इसको otherwise लेंगे suppose कि यदि आपका काम सही है,
Your Lordship, there should
why
be some
why were you are required to upgrade in any capacity?
Your Lordship, they are writing adverse remarks in my ACR behind my back, not even giving me that ACR. What their rule? Your Lordship, the official respondent does not follow any rules. The official, when you see the confidential rules, it clearly says that every ACR for the year should be communicated to the concerned officer on or before 15th August. So why they have not communicated me that ACR? And they have full right. I am their employee. They are superior officers. I am nobody else. They could have terminated before 3 years. Why they have waited for 3 years? Or what is successful meaning? If we go through the literal meaning of everything, that they would have justified everything. That successful means this and that and that and that. The rule simply says what they themselves have made. They themselves have formed these rules, and it their right shall. They should have wrote me. Why they have right shall? And now they have themselves wrote the rule 5, where they themselves says on completion of probation. They would have said that there must be some test, there must be some other thing. We will, in our whims and things, we will see that who will be the able judge and who will not be disqualified. What are the complaint? How they can say I was not, like, what they're considering is totally, like, what they want, they do.
Yes.
They're not following their own rules. Or what they say about the confidential rules, communication
Yes,
rules.
Mr. Das, why you have not communicated the adverse remark in the SCR within time so that she can upgrade her performance?
Lord, if Lord may have a look, Lord, in my reply.
Suppose
Well,
within time you have not communicated.
I could get what my Lord is referring to. If my Lord may just have a look at page number, this para 23.
Because the sole purpose of communication of the adverse remark in the SCR is to upgrade to give an opportunity to upgrade the performance.
My Lord, she was communicated.
She was communicated after termination. Please specify it. After termination and till the time I was not in service.
आज मेरा काम खराब है, मुझे आज कम्युनिकेट करोगे, मैं आज सुधार लूंगा.
My Lord,
आज से 5 साल बाद मुझे कम्युनिकेट करोगे तो हाउ माई परफॉर्मेंस एज ऑन डेट could be assessed after 5 years.
my Lord, I'll put it in a different way. My Lord. As far as the consideration of the probation period is, my Lord, communication of the ACR or non-communication of the ACR would be a different aspect altogether.
क्यों?
My Lord, how you had performed your work is what we'll be examining when we are considering whether or
तो
not.
आप बताओगे ना कि आपके काम में ये कमी है.
Yes. Now, my Lord, if my Lord may have a look at page para 23 of my reply, my Lord. Para 23. Para 23, my Lord. I read from second line. ACR for the year 2015-16 was duly communicated to the petitioner on 10/4/2017.
10/4/2017 after the retirement.
After the termination.
Termination.
The submissions made by the petitioner are self-contradictory to the submissions made in para 9.7. There is no representation ever submitted by the petitioner to the ACR for the year 15-16.
So till that time she has already terminated.
My Lord,
What result would come if she has made her representation or not?
my Lord, even after she was reinstated, even after, because today when they say, my Lord, that क्योंकि मेरे को ये 10
बताइए, आप तो कंसीडर कर रहे हैं 2015-16 के एसीआर पे.
My Lord,
On the date when it was
and
communicated, she was already
and the
terminated.
past service also, because my Lord, the entire service was looked into.
Past service, Your Lordship, 2 years probation. 14-15, there is no ACR. 15-16 is the main everything basis for the termination. 1516 is
What
the
was
basis.
considered, my lord, is at page 62. Page 62 of the petition, my lord. Page 62, my lord. The last paragraph. The standing bulletin fund.
Yes.
The above narration is with regard to the jurisdiction, no? They referred to the amendment that has taken place under Rule 4C. And then, Lord, they record that it is the standing committee which has now had the jurisdiction. Then it says, Lord, the standing committee, considering the overall performance, entire service records, and the ACRs, including the assessment chart of Kumari so-and-so, found that she is not fit for confirmation in service. Therefore, it is resolved to recommend termination of a service under sub rule 4 of rule 11 of the Chhattisgarh Lower Judicial Service Recruitment and Conditions of Service 2006.
ये तो वही बात आ गई ना फिर से कि इनका जो पास्ट सर्विस रिकॉर्ड है दैट हैज बीन कंसीडर्ड.
यस, बिकॉज वही पीरियड है इनका काम का. क्योंकि मेरे को तो इनका जो पीरियड है पिछला उसी को देख के डिसाइड करना है कि वेदर आई शुड कंफर्म और नॉट. द फर्स्ट ऑर्डर, my lord, which was passed, that is the reason why I referred to that portion, my lord, of the first writ petitions order, which remains unassailed, because that part has attained finality. This is, my lord, para 35. क्योंकि ये जो आर्गुमेंट है ये वहां पे भी था and it was addressed, para 35.
35 of the order of the first round.
First round. Annexure R21, no? Para 35. Further submission. Because this has not been assailed. This part of the order, my lord, this has attained final. Para 35.
35 na?
Para 35. Toward the bottom starts. Further submission of the petitioner.
Yes.
Further submission of the petitioner that ACR of the petitioner, which was graded D, has been communicated after the order dated 31/1/2017 of termination was passed, and the same has lost its significance in view of the law laid down by the Honorable Supreme Court in the case of Devdutt and Sukhdev Singh, also deserves to be rejected, as the standing committee has assessed the overall performance of the petitioner. Thereafter, impugned order has been passed, which does not vitiate the decision of the standing committee not to confirm the petitioner on the count of non-communication of the ACR for the year 1516. So this was considered answered. This finding, my lord, has already attained finality. She did not challenge this.
Your lordship, they have that time said that because this ACR was not conditional.
इसमें तो देखिए, इसमें जो है दोनों कॉलम है इसमें तो non consideration of the performance, consideration of the performance as well as non communication of the ACR.
नॉन कम्युनिकेशन ऑफ ACR के कारण
उन्होंने कहा कि ओवरऑल मतलब इन्होंने what had happened, the honorable single judge on merits have answered that yes, non confirmation is correct, but then since it has been done by the standing committee which did not have jurisdiction, therefore the order is bad. It is sent back to the standing it is sent back to the High Court to act according to the rules.
The order does not say that.
I'll answer. So therefore, this finding of para 35, my lord, remains unassailed. And this says, assess the overall performance of the petitioner. Thereafter, impugned order has been passed, which does not stand vitiate. It does not vitiate the decision of the standing committee not to confirm the petitioner on the count of non-communication of the ACR for the year 2015-16. And then finally, my lord, para 38. Accordingly, the writ petition is allowed in part reinstating the petition on a formal post with continuity of service but without back wages, reserving liberty to the respondent to proceed further in accordance with law if this so desires. This was further clarified in the writ appeal, saying that it was allowed only on technicalities, because the last para of the writ appeal at order, my lord, in the facts and circumstances of the case, having regard to the administrative norms adopted on the, the writ appeal at
79.
Yes, para 23. In view of the above findings recorded by learned single judge, petitioner, except relief of back wages, has not challenged other findings recorded in the impugned order. So that order, that portion which I had referred to, Lord, para 35, that was not challenged. Has not challenged other findings recorded in the impugned order, and further considering that writ petition was allowed on technical ground, this court is of the considered opinion that there is no substance in writ appeal, the same is liable to be dismissed. Now it is that technical part which was taken care of.
So this writ appeal 362 was filed by you.
Yes, well, there were two writ appeals.
362 is filed by you.
362 was filed by her. 363 was filed by us. Well, page number 58.
362 filed by her.
Filed by.
Yes, madam.
Your Lordship, they have not given me ACR. That I have said that they have only given me excerpt from the ACR. It was not the ACR. It was just from it was just excerpt. It was just adversary remarks which they made against me. They have communicated me after my first termination, and then in writ appeal, in a writ petition, they have said that because we have not communicated this ACR to the petitioner, that's why we have not taken consideration of that ACR before the termination, first termination. That time they said, because it was communicated after my first termination, and the first termination for the this meeting was held on 31st January 2016. That time this ACR was not communicated to me. So that time they said that it was because it was not communicated to her, that's why we are not taking consideration of that ACR for this termination. And now, as we see in page number 83, they have considered that ACR of 15-16 and then 16-17 without giving me an opportunity to represent against those ACRs. And they are saying it's been 8 years. Why you have not represented? Your Lordship, I was not in service. And how I will assume that within 1 month, I will again get terminated? And their own rules says within 15 days you have to represent against those adverse remarks. So that 15 days is already passed, long back. Now how I can represent? And 16-17, where I have not got an opportunity to even write my first to appraisal form. And they have recorded that ACR.
So that is why I say, my lord, this communication of the ACR or non-communication is entirely a separate part.
Your Lordship,
we have to assess her work.
Just a minute.
We have to assess
that
the work
is not that is not a separate part, Your Lordship, because I have filed a RTI asking them that what are the documents you have placed before the standing committee before my for deciding my confirmation for this time. That this meeting they held on 6th January 2025. And they have given this P22 document. And these are the documents they have considered.
Where is the order of your reinstatement?
Reinstatement is...
P15, 14.
P15.
14.
So when you have reinstated her, does it not amount to condonation of the earlier?
No, because the Honorable Court has permitted us that you act in accordance with law. We are giving you that liberty because she will still.
So what act you have done? What consideration?
We had again considered whether or not to confirm.
Whether you have given her any opportunity
to represent.
We have to assess her. We have to assess the work discharged.
You assessed on your own.
We have
what steps you have taken to ask for the reply of the...
Before confirmation, no opportunity is to be given. The work has to be assessed objectively by the employer. So, my lord, we had considered the work discharged
Before
by
assessment,
Before
before assessment, have you given any opportunity?
Not
to,
at all required, my lord. The rule does not say that I have
क्यों
to give
ACR
me
ACR तो communicate कर रहे हैं ना आप इनको?
that's a separate part. ACR
ACR आपने suppose अप्रैल में consider कर भी लिया या ACR आपने communicate कर दिया. She has made her representation against that ACR. ठीक? Have you considered that aspect?
Well, you know, the INA representation, because that ACR was communicated to her long back, 8 years back. Now she had not preferred any representation.
नहीं भी दिया है तो you
Your
have to
Lordship,
wait.
I was not in service. How could I represent? On what ground? Because that was communicated on 2017 and I was reinstated in 2024. How? I will assume they have already taken 7 years to decide that case only. And their own rule says you have to represent again within 15 days. How I will, that time I am busy with my filing this writ petition, that earlier writ petition. Can you see the mental trauma also?
क्योंकि आपने जब दोबारा कंसिडर किया उस समय तो इनका जो ACR था वो कम्युनिकेट किया आपने 17 में and that has been considered in the year 2024.
Her entire career, the work that she had done was considered,
So,
including that ACR as well.
Before reinstatement, all that material was with you.
It was with me, my lord. It was with her also. But since the order of termination, my lord, was set aside on technical reasons, saying that the authority, the standing committee did not have the power, therefore, liberty was granted. Because we have to take a decision with regard to her confirmation or non-confirmation.
But when the learned single judge has not considered your consideration of her performance.
Well, the honorable single judge, my lord, had considered what went with the standing committee. On merit, he said that she had failed to demonstrate that there is any material to vitiate the decision. But since it is the jurisdiction of the authority, the court said that I will not permit this order to stand. However, you may take an appropriate steps under law. So it was sent back. They again placed it before the competent authority. The competent authority took a decision. And those findings, my lord, of the honorable single judge has attained finality because she had not assailed those findings.
Reserving liberty to the respondents to proceed further in accordance with law if they so desired. By exercising this liberty, you have again
placed it before the competent authority that whether she needs to be confirmed or she need not be confirmed. Then they took a decision she need not be confirmed. So it is not, my lord, it is not an order of termination, my lord, which we otherwise understand in general connotation, where a departmental inquiry and based upon certain allegations, somebody is chucked out of the job. No, it is a question, my lord, where it is either confirmed or non-confirmation. So that would again not follow the principles, my lord, of.
So the effect of that termination would be she has not been confirmed.
She has not been confirmed. There is no. It is not stigmatic.
It is not that she has been confirmed and then on allegation she has been terminated.
It is not one of those cases. Had it such a situation, then my lord, the judgment of state of Odisha and Bina Pani, my lord,
वो फिर तो दूसरी बात है,
line of
दूसरी बात है वो तो फिर.
So here that it's so
here that in 11.5 she has not been confirmed.
She has not been confirmed. She has not
as
been
per clause 11 sub clause 5.
She has not been confirmed because she could not successfully conclude that period of probation.
Yes, madam.
wanted me, not INSAF. According to their own rules, but they are now, just because they have done something, they are now insisting on the rule and they are now interpreting that. But they have not given any interpretation of that rule. They would have not given any provision clause on that rule. What they have written is shall. And now they are treating it as a may. So what is the meaning of the making such rules? They should have said the High Court made it. It can confirm. Why they have written shall? And your Lordship, what they are saying, entire service records, entire performance. Your Lordship, I had joined on 27 December 2013. Then I was for the 2 years of probation. Then I went for the institutional training. My last institutional training was ended up on 2016. December 2014. I completed my third part of finally my last institutional training was completed on 2014. And then 2014, I got complete rank. 2014, December 2014. And then 31st January 2015, I got GMC power. And then 10th February 2016, they have appointed me as in the additional charge of the juvenile justice, principal judge of the juvenile justice board. So I actually, first time I got the independent charge of board in August 2000. After 31st January 2015, I started working as a JMFC. And then they have recorded 1516 ACR that she would not be able to discharge any other job. This is the person who just entering into the judiciary. I am probation. There are some time to learn everything. So what is the entire service record, entire service? Is there any complaint against the integrity? Is there any complaint of any forgery? Anything? No problem. Just because of ACR, I filed complaint against my senior. Now they are taking the ACR of what they have written behind my back, and now they are taking advantage of that ACR, saying that they are taking moral performance. What does it mean by moral performance? I started working in 2015 only. And they are not even giving me any warning before writing that she would not be able to discharge any other job. She is saying complaints are alarming. No complaints are decided by this court. Not a single complaint they have decided against me. And they are taking those ACR for this termination, and they are saying we are just taking because we got the liberty to do according to law. And they are taking advantage of those ACRs which I already said that expel those ACRs. But that honorable bench has not decided regarding the exchange of their adverse remarks which are written in 2015-16. Yes, I was because reinstated with continuity of service and consequence of benefits, no seniority. So I thought I got my job back, nothing to fight again and again. But since they have not granted me back with this, I fought back with it.
Yes.
Now they are again taking advantage of those ACRs which I already pleaded in my first petition to expose those adversaries. You can see clearly in page 83 of my submission, they have never given me a single warning throughout my service period, but writing that she would not be able to discharge anything. And she complains are alarming, but not a single notice, not a single warning. 83. Page number 83, Your Lordship. Annexure 22, punishment, warnings, etc. given by the High Court mail. If they are not following their own rules, not the guideline of given by the Honorable Supreme Court. We have communicated. It doesn't mean that I would not in service. How would I represent this?
Yes.
But still, the standing power, standing committee does not have power to recommend the termination of a judicial office. Yet, if for the sake of argument, we take it as I am a probationer, but the still standing committee does not have power to recommend the termination of a judicial officer. The rule, what they newly amended in 2023, the rule still says what the rule. Rule 4C.
Page.
Para 9.1. This rule, which they have now again invoked and terminated me, this rule says 17. To dispose of any other matters which are not covered under Rule 4C, excluding matters covered under Rule 4O. Your Lordship,
What is the 4O?
9, 10, 4O says, on the following matters, decisions shall be taken by the judges at a meeting of the full court. He says all recommendation for the dismissal from the office of judicial officer, and this is also this was also decided by this honorable division bench of this honorable court in the case of High Court of Justice versus Dennis from Burma. In that case,
Then para
30. Rule 4 must be made it clear that all recommendation for the dismissal from officer has to be pursuant to a decision taken by the judges at the meeting of the full court. 32 says, in view of the above discussion, there is no escape from the conclusion that the decision of the standing committee recommending termination of the service of the petitioner was without reservation. We are fully in accord with the view taken by the learned civil that since the High Court has not made any recommendation in terms of such and such rule to terminate the service of the writ petitioner, the order of termination passed by the respondent number 2 on the basis of recommendation to the standing committee is unconstitutional, non-is and without authority. The 4O of I1B is still there. And it still is excluding under the power of the standing. So now they can again cannot just invoking this new amendment, they cannot terminate through this recommendation of this.
what do you mean by High Court?
High Court is defined under 416 of the Constitution, Your Lordship, which says
Since the High Court has not made any recommendation in terms of Rule 9(4) of the Rules of 2006, how? So how do you define the High Court in this context?
in addition to the other cases that are
So it means a full court meeting. Not by the standing committee. Yes, Mr. Das.
The word used is dismissal. There is a difference between dismissal and termination.
No, you
Removal-
are on the point that it is not a dismissal.
It is not a dismissal.
It is.
It's basically a
There is no
non-confirm.
confirmation.
Yes. The
It
word
is not a
used-
dismissal.
Yes, Lord, it's not dismissal. It is not on basis of any misconduct.
You are taking advantage of
No,
that
no.
fine
In
line.
fact, this amendment was prompted after this Burman's judgment.
Huh.
After the Burman's judgment, my lord, that judgment was allowed. It was acted
The rules
upon.
was amended
The rules were amended. The matter
after
was
this judgment.
after this
Burman's
Burman's
judgment.
judgment.
Read in 9.1, 9.11 para. This is new amendment.
Para 9 point.
9.11. This is the new amendment.
17 जो है
17.
to dispose of any other matters which are not covered under rules 4C, including matters covered under rule 4O. So 4O is specifically provides for recommendation for the dismissal. Nee, that is why he is saying that it is not a dismissal. It is not. It is non-confirmation of your service.
Your lordship, but the recommended termination, if you see the words in the page number 62, not confirmation is differently and recommending for the termination is differently. The standing committee considering last paragraph, page 62, the standing committee considering the overall performance entire subject record and the ACS including the assessment chart of Kumari Kashabadar found that she is not fit for confirmation service. Therefore, it is resolved to recommend the termination. The word is recommend the termination. And the rule says the recommendation must be done by the High Court, and the rule specifically says the High Court means the High Court of Chhattisgarh, and High Court means what the Article 216 says is the full court. And this matter is already decided by the Burman by the Honorable Division Bench. And
So earlier it was mentioned that she is not fit for confirmation in service. Therefore, it is resolved to recommend termination of service. So termination does not include the non-confirmation.
But the period.
Termination means stoppage of a service.
Yes. Determination. But the word
By
of determination.
non-confirmation, by removal, or by whatever nomenclature it would be.
the rule says you are not
Termination is a composite
Composite.
meaning. Composite meaning.
the rule says the rule 3 the rule 4 11.4 probation 11.4
Hmm.
the High Court is also the High Court. And here the meaning of High Court, if you see 2B, 2F. The lordship 2G of this rule only. The High Court says the High Court of Chhattisgarh.
Hmm.
And the committee is also defined in this rule, your lordship. The committee is also defined in this rule only. The subject rule. Yes, the
2B.
committee.
Hmm.
This committee is a committee consisting of one or more judges of the High Court nominated by the Chief Justice for supervision of recruitment process conducted by the Commission. Here also nowhere it says the committee is standing or nowhere it says that we are conferring the power to become the termination of the standing committee. We cannot go beyond the rules for every aspect. This rule is framed by the point number 2 only. All this is perfect. They could have amended everything. They have power to amend everything.
Yes.
Communicating ACR is also a rule framed by the High Court,
Hmm.
where they themselves say every individual shall be communicated on or before 15 hours. If they say regulation 7, you lost. Regulation 7, note. Preparation of ACR and its time limit.
Hmm.
To note is every individual shall be made by the authority in early finalization of confidential reports was to enable the authority to communicate the final completed confidential report to the
क्या पढ़ रही हैं ये?
note to regulation 7 का note.
Note 2.
ये regulation 7 confidential course का regulation.
So is it a part of the writ petition? Is it a part of the writ petition? कहाँ है? Page 13. Hmm. Hmm. Para 9 points. Rejoinder para.
Your lordship in para
18.
para
9.17 of the writ petition.
of the writ petition.
Hmm.
Here I have mentioned the rule, regulation 7 of this Chhattisgarh Judicial Officers Confidential Rules Regulation 2015.
Hmm.
Regulation 7, preparation of API and its time.
Hmm.
Here it says it has 6 parts.
Yes.
In the note, your lordship, every individual shall be made by the authorities in early finalization of confidential reports so as to enable the authority to communicate the final concluded confidential report to the member of the service on or before the 1st of August.
Hmm.
This is the rule framed by the High Court. They are not following this rule.
Yes.
Here also the word shall includes. Now they can also say it is made. Whatever rule is framed by the High Court only, they are not changing that rules also, not the honorable directions of the Supreme Court also.
Yes. Yes, Mr.
Lord,
Yes,
may I
madam.
have-
एक minute. Anything you want to add? Hmm. Hmm. वो तो नॉन कम्युनिकेशन ऑफ द ACR पे है. There are subsequent judgments also. Hmm.
Improve the work performance.
Hmm.
They are not like if they feel dissatisfied with the remarks.
Yes.
They are taking represent. So if they are the ACR is not communicated within the designated time, it is the violation of article 14.
Hmm.
And the next thing I also want to say is the way they serve me the order of termination.
Hmm.
Your lordship, please para. Para 9.28, Your Lordship. Page number 25 of my restitution.
9.28.
The P80 at para, page number 52.
52.
50. Both bit together.
Hmm.
Your Lordship, this saw the termination order. The order was of 14th January 2015.
नहीं, page 52, exhibit P18.
Received with exhibit P580,
Hmm.
P80.
Hmm.
Then the related para is 9.28 at page number 25.
Hmm.
Your Lordship, they terminated the
Hmm.
termination order, that is 14th January 2025.
Hmm.
On 15th January 2025 at midnight 10:35 p.m. when I was in my residence with my small child of 5 and my husband was not with me at that time. The district judge, she called me, he sent her driver, they took me from my house to his place and they served me notice at 10:35 in the midnight, you know. And they asked me to leave at 11 p.m. The way they served me the termination
Hmm.
is the way to serve a termination order. Is there a rule which says that call anybody at midnight and terminate her? Am I a criminal? They could have served me on 16. They would have not paid anything to me. But calling at midnight, what was the urgency?
Yes.
They say we have duly communicated you with the, we have duly served you the termination. What is the mindset?
Yes. Hmm. Yes, Mr. Das.
But if Malord may have a look at the High Court rules, Malord, 2007.
Hmm.
The High Court rules 2007. It
2007
defines
7 rules.
2007 rules.
Hmm.
Under the 2007 Malord, definition clause,
Hmm.
Rule 2S talks about the standing committee. Malord.
Just एक मिनट, उससे पहले बताइए.
Malord.
Is there any dispute that in the night at 10:30 you have served the termination order? What she has referred just now.
Well, because the order of termination was sent, Malord, to the district judge for service.
Hmm.
The district judge
The
would have.
time which has been mentioned by her
Malord.
at 10:30 p.m. and at 11 p.m. she has been relieved. What do you say about this?
Malord, the service has been done, but the
Is this a way to serve
it could have
any
been,
order upon a judicial
it
officer?
could have been in a better way, Malord. Instead of insisting on the very same day.
So does it not about the mindset
No,
of the authorities?
No, it will not, because my lord, the communication what
when
was
it has
served,
been sent, when it has been sent to the district judge, when it has been sent to the district judge,
that record is not there. That detail is not available.
hmm?
That detail is not available.
This is on the same day, 15/1/25.
14. The order is on 14. Annexure P2.
नहीं, received a closed envelope containing endorsement number so and so, dated 15/1/25.
Malord is referred to page 50.
Page 53. The closed envelopes was sent from this court from this court on 15/1/25, and on the same day, same night, it has been served. Page 53 में
Yes.
number so and so, dated 15/1/25.
It was dispatched from here, Malord. It appears it was sent from the confidential section.
On the same day, it was dispatched. On the same day, it was received by the district judge. On the same night, it was served with the judicial officer.
No.
Does it not amounts to mindset?
Malord, it may not, Malord, because the haste that the concerned officer had shown, Malord, in serving it may not otherwise.
Concerned officer है, तो भी
Oh,
it has been
she
served
could have
upon a
been-
judicial officer.
Yes, Malord, could have been in a better, polite way, Malord. On the next day, it could have been served. There was no haste to serve it on 10:30 in the night. If I take this to be correct, Malord, because I'll have to take the version whether 10:30 I may not make any allegation, Lord. I take it that the petitioner is submitting what she is submitting she's submitting it correctly. So I'll not, Lord.
Right? You are treating her terminated on 15/1/25
On
itself.
15-1.
ठीक?
14. In fact, the order is on 14-1.
14/1,
So-
but you have treated her to be terminated from 15/1.
No, the termination would come automatically on the issuance of the date of the order.
14/1.
14-1. Unlike the order of suspension, the order of suspension comes into effect on the date of service, whereas the order of termination, Lord, would come into effect on the date the order is issued.
It states from the date of service of this. It doesn't say immediate.
Yes,
From
is
the
correct,
date of
Lord. From
service
the date
of this order.
of this order. I stand correctly.
In the
15.
reply, Your Lordship, the para 9.25, what I wrote, in the reply you can see the reply of the Honorable Respondent number 2. They say they haven't said anything about the time and anything, but page 13 of their reply. Para 13. The reply of this para, Your Lordship. That the contents of the said para are absolutely misconceived and misplaced. The contents of the said para are repetitive of para 8.11, 11 of the instant petition. The said submission of the petitioner is wholly concerned for the purpose of
But I'll not join on that because that may even if we take it, my lord, that but then it could have been the only anxiety would have been, my lord, the next judicial working day. वो भी
9.28. My petition was in 9.28 at page 25, and their reply is 32, para 32, page number 14. What they replied of all my this thing, what I told now to this honorable court, that the content of said para absolutely misconceived and misplaced. The petitioner has simply made bold and baseless allegation against the answering respondent. The answering respondent have acted strictly in accordance with law. They have replied. Now, what they is saying, I can't say that he is not seen the document before making this reply.
what wrong reply I had given, my lord? Let me now counter this one. What wrong reply we had given? It is not that you can make any sort of a statement and allegation and you can walk away. We had said that yes, it was rightly served. We had not commented upon this. Absolutely nothing. There is no comment.
Just a minute, madam. You have already argued. Let him reply. You may counter his reply. Yes.
My lord, what I was submitting was, my lord, if my lord may have a look at the 2007 rules.
2007 rules. Yes.
Lord, Rule 2S. My lord.
एक मिनट. The subordinate
No. High Court rules.
High Court rules.
High Court rules.
Rules
Rule 2S.
2S.
The High Court rules. Rule 2S.
Standing committee.
Standing committee. Standing committee means the committee constituted under these rules. Then, Lord, Rule 4A. Not 4A. Yes, 4A.
4C.
4A. 4 capital A. Lord.
अच्छा. 4A. हाँ.
Rules for disposal of non-judicial business. Rule 4A. There shall be a standing committee composed of 1, 2 judges nominated. Then 3, my lord, 2 judges nominated by the Chief Justice by rotation. So. Then 4B, my lord. The standing committee shall be charged with the control and direction of the subordinate courts so far as such control and direction are exercised otherwise than judicially. Then, my lord, 4C. The standing committee shall have power without reference to the judges generally. And then, my lord, 1, 2, 3, 4. There is an amendment, my lord, made after the judgment in Berman's case, my lord, where clause 17 was added. Roman 17.
4C में Roman 17.
4C में Roman 17.
This was amended. Including 15 and 16.
My lord, including 15 and 16.
है ना?
My lord. There were 3 clauses which were added. 15 was what? Matters relating to the service conditions, facilities and amenities of the judges of the courts. 16 was rules which will be published, will have the force of law. 17, to dispose of any other matter which are not covered under Rule 4C, excluding matters covered under 4O. Then, Lord, we refer to 4O. Now, this was an amendment, Lord, which was brought in 2023.
Yes.
4O. On the following matters, decision can be taken by the judges at the meeting of the full court. So they had excluded, my lord, 4O. So anything which is not to be done by 4O, my lord. Then what 4O says, my lord? All appointments which by law are to be made by the High Court. 4OB says all recommendations for the dismissal from office of judicial officers.
So it is not the dismissal.
It is not a dismissal. That is what our argument is, my lord. Dismissal means, my lord, where there is a department
non-confirmation of
the services, and since the services
as per your submission,
my lord, and since the services have to be brought to an end, the term of termination has been used without making any. My lord would see, my lord, that order does not cast any aspersion. There is no allegations which are stigmatic. It does not say in any way, my lord, what are the charges, to level any charges or to allege any charges. It simply says that she is not found to be fit to be continued, and therefore her period was, her probation was concluded, my lord, and she was terminated.
Is there any word termination defined?
My lord, the words termination, removal and dismissal. Removal and dismissal have been...
Termination is, might be some different...
My lord, because under the CCA rules, my lord, the word dismissal and removal has been referred. One says, my lord, where it will be
termination may be by any reason.
By any reason. It's not something like when a lease is determined.
Yes.
So we are determining the lease. It is finally coming to an
Any period which has been stopped.
stop. So that is where it is terminated. So your continuance of service on probation is hereby terminated. So it is ceased, brought to an end.
Here word dismissal is used.
Here it is
For
dismissal.
OB.
For 4B, dismissal.
Yes. Yes.
Well, so therefore, my lord, this 4OB is not a case, my lord, which will cover the present case of the petitioner. So this argument of the petitioner, my lord, to say that the standing committee was bereft of jurisdiction, my lord, that will not hold good, because the standing committee's powers are being conferred under 4C17. And this has been specifically referred. If my lord may have a look at the recommendation which was made, page number 62
Of the writ petition.
of the writ petition.
17 of 4C.
17 of 4C. By virtue of insertion of clause 7, my lord, I am referring to second para after resolution.
Now by virtue of
Now by
insertion
virtue
of clause 17 of
17 of 4C of the High Court of Chhattisgarh rules by notification dated so and so, the power to consider the case of confirmation of so and so rests with the standing committee. So again it says, my lord, that it is what they are considering is whether or not to confirm her services.
Powers of confirmation.
Powers of confirmation. Because I'll again juxtapose this, my lord, to that rule 17. 17 says to dispose of any other matter which are not covered under 4C. And 4C, my lord, contains other clauses as well. उन सभी clause में कहीं पे भी ये confirmation, completion of probation in words का कहीं there is no, absolutely no mention. Therefore, the standing committee, my lord, has been conferred with this power. What is to be done by the full court? 4O. What is to be done by the committees, my lord? Then they have delegated the power. And these are again, my lord, statutory rules. So unless and until she goes on challenging this very clause in the amendment of the rules, this argument, my lord, to say that it is covered under 4O shall not hold good, my lord. Lord, if I take help from the CCA rules, my lord, well, this is rule 10 of the CCA rules. Rule 10, there's an explanation, my lord, after Roman 9. Roman 9, my lord. After Roman 9, my lord, there is an explanation appended. The explanation says, the following shall not amount to a penalty within the meaning of this rule. Because rule 10 talks about penalties, minor penalties, major penalties. Then this explanation says that the following will not include penalties. Under that, my lord, under the explanation, Roman 8, termination of services of a government servant appointed on probation during or at the end of the period of probation in accordance with the terms of the appointment of the rules and orders governing such probation. So if the services are terminated on account of a probationer on non-confirmation, it will not amount to any of the penalties under Rule 10. If my lord may just have a look at the rules, my lord, of the CCA rules. The CCA rules, my lord. Rule 10, my lord.
में देना, लोकल एक्ट में देना, CCA rules. अरे ये कंडक्ट रूल नहीं,
नहीं कंडक्ट रूल, क्लासिफिकेशन कंट्रोल
एंड अपील रूल्स,
वो वॉल्यूम 3 में ही होगा।
हाँ, रूल 10.
Now my lord would say, my lord, penalties,
हाँ,
minor penalties 1 to 4, major penalties from 5 onwards, my lord. Now if my lord may just have a look, my lord, at Roman 8,
हाँ,
removal from service. So this is a penalty. Then my lord, Roman 9, dismissal from service.
हाँ,
So both, my lord, removal and dismissal are penalties. Then my lord would see, my lord, explanation.
the following shall not amount to a penalty within the meaning of this rule.
This rule, namely, and then my lord, I'll request my lord to kindly come to Roman 8. Termination of the services of a government servant appointed on probation
During or at the end of period of his
of
probation,
his probation.
in accordance with the terms of his appointment of
The
or
rules,
the rules
orders,
and other governing.
So my lord, the termination of the services,
Hmm.
as my lord said, my lord, it is bringing to an end. It is terminating. It is bringing to an end. It is not on account of any allegations of misconduct. Because on allegations of misconduct, then it is either removal or dismissal. The removal is that it is not a disqualification for future employment, and dismissal would be that it is a disqualification for
So
future employment.
termination means her services work came to an end on account of
Confirmation
of her
of her
services.
probation. my lord. So therefore, my lord, the principles that a prior show cause notice had to be given, that is also not the case.
If there is an allegation, if there is requirement of any departmental inquiry, then
my lord, then.
yes.
Therefore, my lord, the standing committee considered, my lord, the entire facts. They had examined, my lord, the entire service. I'll again emphasize, my lord, the entire service record of the petitioner. It was examined, considered, and then a conscious decision was taken. So while exercising the powers of judicial review, my lord, while invoking this 226 petition, my lord, the judicial review on the substantive, my lord, the objective consideration, unless and until it is violative of any of the statutory rules where the petitioner can demonstrate, the Honorable Court, my lord, will not sit as a court of appeal over the decisions taken, my lord, considering whether or not the services are to be confirmed.
But
And
if there is any arbitrariness,
if there is any arbitrariness, if there is any arbitrariness,
malafide,
they'll
arbitrariness,
have to plead. They'll have to allege. Malafide will have to be specific. It has to be a malice in fact with specific allegations.
So the manner in which she has she has argued on the point that the manner in which the termination order or removal order is served upon her.
Yes. But that may not be, it is not encouraging. The manner it was done, it is not at all encouraging, and we cannot support such a way. But nonetheless, that will not vitiate the decision taken by the standing committee.
No, that alone does not vitiate, but that can be considered if it has been served with in a proper manner.
But it should have been in a more better.
In addition to that, in addition to the other grounds or other circumstances, it may be a corroborative piece of.
It could have been, but it could have been provided there were no other material otherwise to demonstrate that there was a decision was taken or. So because the findings recorded in the first round, then my lord, the findings now it was sent back, it was considered, examined, and then again, my lord, the decision was taken. So in my respectful submission, lord,
you have not gone before the Honorable Supreme Court.
No, we have not.
You have not challenged that order.
No. We had abided by the judgment, lord, because what had happened, lord, the day the writ appeal was being considered, the amendment had already come.
Why don't you have said that no, since their performance is so poor, we will not reinstate him?
No, because my lord, the order was set aside. This recommendation made by the standing committee was set aside on technicalities. So the moment the
technicalities,
yes,
not
therefore,
on the poor performance.
Yes, my lord, not on poor performance. Therefore, we had argued before the honorable court that sending it back to the standing committee may be a futile exercise, because on the merits of it, it is only on the technicalities. The court said that no, because we referred to a doctrine, my lord. We had referred, my lord, that since it will be sent back, and now the authority is conferred with the jurisdiction. Unless and until that judgment of Burman had come, my lord, the decisions were taken by the standing committee.
बर्मन का जजमेंट तो 2023 में आ गया.
23, इसीलिए उसके बाद अमेंडमेंट हुआ. 23 तक स्टैंडिंग कमिटीज के ही ऑर्डर्स हैं सर. So they were under this.
When this order has been passed in the first round.
In the first
24 में ना.
24.
उसके पहले तो बर्मन का जजमेंट आ चुका था.
बर्मन का जजमेंट आया. इनका पहला टर्मिनेशन बर्मन के जजमेंट के पहले.
हाँ 2017 में ना. 17 में टर्मिनेशन था.
तो वो उस समय बर्मन का जजमेंट नहीं आया.
बर्मन जजमेंट कम इन द ईयर 2023.
So at that point of time, everything was being done by the standing committee. Then Burman's judgment came. Standing committee's orders were limited, but not restricted. We preferred an appeal because by that time, after Burman's judgment and the judgment in the writ appeal, there was this amendment of 23. Because her first round writ petition was allowed, my lord, in 2024. First of May 2024, because 1st of May 24, by that time the amendment in the standing committee was already there.
1524.
1524 is the writ petitions order. And the amendment was in 23.
Yes.
So by that time, my lord, since the amendment had already come, the argument was that now that the power is already conferred, so the court said that no, it is on the question of jurisdiction. We will not consider this. The orders on the day it was passed, it was without jurisdiction. We'll set it aside. However, you will have the liberty to take a decision of it. So because if the writ appeals order, if my lord may have a look, my lord, the writ appeals order considers this entire argument.
Yes.
This, my lord, would see, my lord, page 62. 62 of my reply. Page 62 of my reply. This would be, my lord. 10th line, my lord. He also pointed out. 10th line.
Para 6 में ना?
नहीं, my lord, page number 62.
Sorry. Page.
Para 5. Para 5 का, my lord. Page internal page 5. This is 10th line, my lord. He also pointed out. Yes. He also pointed out that Rule 4C of the rules was amended by notification dated 23, whereby clause 17 is inserted, empowering the standing committee to dispose any matter which is not covered under Rule 4C, excluding matters covered under Rule 4O, and therefore by application of de facto doctrine, the decision of the standing committee and its recommendation does not call for any interference. Any action of the standing committee of recommending is valid, and decision taken by the standing committee cannot be challenged on the ground of lack of jurisdictional competence. In support of his contention, he placed reliance on so and so. Then, my lord, this argument has been considered. Para 10, internal page 8. To appreciate submission of the learned counsel for the appellant, High Court, we have perused Rule 4 of the Rules of 2007 existing on the date when recommendation was made by the standing committee. existing on the date when recommendation was made by the standing committee, and relevant rules are extracted herein below for ready reference. Then, my lord, para 11, page 11, internal page 11, 868.
Yes. Yes.
Well, apart from the powers under Rule 4C, the Standing Committee under Sub-Rule 9 of Rule 4C is empowered to pass orders of suspension, initiation of departmental proceeding against members of the higher judicial service and subordinate judicial service, and consequential orders in the said proceedings other than that of dismissal from service. In the aforesaid Rule 4C9, the Standing Committee on the date of recommendation was not having jurisdiction to pass orders of dismissal of service, or as dismissal of a judicial officer from service has been consciously excluded in the provision itself. Rule 4C came to be inserted, wide notification so and so, and Rule 417 was inducted as quoted above. Learned Counsel for representing the High Court, pressing upon the amendment made under 4C incorporating Sub-Rule 13, made an attempt to submit that though the power of the Standing Committee granted to dispose of any other matter not covered under 4C, excluding matters under 4O, which include the power of competency of the committee also to make recommendation, and therefore applying the doctrine of de facto, the decision of the Standing Committee of making recommendation is valid. In case of them, these judgments were distinguished. Para 14 now, look, internal page 15.
Yes.
From the above observation made by the Honorable Supreme Court in case of so-and-so, relying upon the decision mentioned above, what is curled out is that de facto doctrine would apply only for the acts of a judge who by some color of law is in a position to an office and for the time being performed the duty with public acquiescence, though having no right in fact. Doctrine gives validity to the act of the officer de facto, whatever defects there may be in the legality of the appointment or election is founded upon consideration of policy and necessity for the protection of the public and individuals whose interest may be affected thereby. Doctrine of de facto would apply only where the authority or a judge would hold office under color of lawful authority, though his appointment may later be found to be defective. In the case at hand, the Standing Committee was not clothed with the power of making recommendation against a member of the district judiciary of dismissal from service. Hence, submission of the Learned Counsel for the Appellant High Court that recommendation made by the Standing Committee of the application of the doctrine of de facto is valid is, in the opinion of this court, not sustainable. In case of so-and-so, Honorable Supreme Court observed that an intruder is one who attempts to perform the duties of an office without authority of law and without the support of public acquiescence. The decision in case of so-and-so, which is relied upon by the Learned Counsel for representing the High Court, is of no help to appellant because in said case, appointment of the additional session judge who had pronounced the judgment after their appointment by the authority has been subsequently held by the High Court to be invalid, and the point of consideration was that what will be the effect of decisions and judgment pronounced by such an additional session judge prior to such declaration of their appointment to be invalid. So this argument was considered, my lord, that whether or not it needs to be sent back. Then the court said that no, it has to be sent back because they were not having the authority at all, and therefore those doctrines would not. After that, after this, my lord, the matter was placed before the authority. The authority considered and again took it. So there are no allegations of any malafide, my lord, because if my lord may have a look at the cause title itself. So had there been any allegations, the officer or the authority so in my respectful submission, Lord, a conscious decision was taken for not confirming the services of the petitioner. The concept of deemed confirmation, which the petitioner strongly harps upon, my lord, that will not come into play because under the rules, my lord, there has to be a decision to confirm the services, and since, my lord, her services were not confirmed and she was found not fit to be confirmed as a judicial officer, her services were terminated.
Yes. Yes, madam.
Your Lordship, this amendment, the amendment of 23, it came before the first judgment of the single judge, Honorable Single Judge. So he considered this amendment in his judgment, Your Lordship.
Yes.
Your Lordship, the Honorable Single Judge has considered this amendment in his judgment, that is in para 27 at page 43 of reply. Para 27, page 43.
Of the division bench.
Of the R2, single judge, Honorable Single Judge has considered this.
Para
27, page 43, Your Lordship, the judgment.
27.
Yes, Lordship.
हाँ.
The Honorable Single Judge before
जो
pronounced,
4C को consider किया.
Your Lordship, this amendment was considered.
Rule 4C of the High Court rules has been amended. ये
Yes,
है.
Your Lordship.
ये बोल रहे हैं ना?
Yes, Lordship. It was considered by the Honorable Single Judge in writ petition, and after considering this amendment also, he passed, the Honorable Single Judge passed this 36, page, para 36 at 56, saying that, thus in view of the above discussion and considering the law laid down by the Honorable the Supreme Court and also considering the fact that the petitioner of probation had her probation period has not been extended,
Where you are reading? Para
36, 56, page number 56, para 36.
read कर रही हूँ.
36, Your Lordship.
After considering para 27.
27, Your Lordship. The Honorable Single Judge has considered that
Thus
amendment.
in view of the above.
Yes,
ये
Your
पढ़ रहे हैं ना?
Yes, Your Lordship.
हाँ.
Thus, in view of the above discussion, considering the law laid down by the Honorable the Supreme Court and also considering the fact that the petitioner was probationer and her probation period was not been extended, considering the overall performance which does not require inquiry as the petitioner, not entitled to get protection under 311 of the Constitution of India, but considering the law let down by the Honorable Division Bench of this court in case of Ganesh Ram Burman, wherein the competency of the standing committee was questioned and it was held that the standing committee was not competent to recommend the case of termination of member of a lower judicial services. As such, I am of the view that the decision taken by the standing committee on 31st January 2017 recommended the
What
case.
was the consideration in Burman's case?
Burman case, this.
He was also terminated during the
Yes, Your
probation
Lordship,
period.
during probation, and the recommendation was made by the standing committee only. So here I wanted to point
Now,
out,
in your case,
Your Lordship,
amendment came into force.
this amendment came before the passing of this judgment, and the Honorable Single Judge has taken consider of those amendment in his judgment also. And after taking the consideration of those amendment, he abided with the decision of Ganesh Ram Burman, saying that standing committee still doesn't have power.
Not still. Was then.
Your Lordship.
हाँ.
No. Your Lordship, the Honorable Single Judge has taken the consideration of this amendment. I just wanted to say that this amendment was before the passing of my writ
देखिए, आगे
petition.
पढ़िए ना.
Your Lordship.
पेज 56 में नीचे से लगभग 8th line.
After your
I am of the view.
Yes, as I am.
As such, I am of the view that the decision taken by the standing committee on 31/1/2017 recommending the case of the petition for termination deserves to be quashed.
Yes, Your Lordship. And this dismissal question, Lordship, what we are reading now in the what we are saying that the power of a standing committee, which is empowered under Rule
वो
4C.
कहाँ लिखा है मिस्टर दास कि on that day
ये on committee on.
वो तो decision taken on standing committee.
हाँ on 31/1/2017.
हाँ.
Your Lordship,
Because amendment आया 23.
नहीं वो जो अभी आप बोल रहे थे it was applicable on that day when the decision was taken.
नहीं ये जो अमेंडमेंट आया ये प्रोस्पेक्टिव रहेगा. तो कोर्ट ने ये कहा कि क्योंकि ये प्रोस्पेक्टिव रहेगा, देयरफॉर 31/1/2017 को जब स्टैंडिंग कमेटी ने डिसीजन लिया उस दिन इट वाज नॉट एम्पावर्ड.
वो गणेशराम बर्मन के ना,
Ganeshan Burman ke usko, then they referred and then they said that it has already been held that the standing committee cannot make a recommendation for terminating the services of a probationer. And following that, the amendment had come, which shows that on the day of 31/1/17, there was no power. तो आज भले ही पावर दे दिया गया हो, लेकिन ये उस एक्ट को उस दिन जस्टिफाई नहीं करे.
Your Lordship,
Which I was trying to argue, my lord, before the honorable division bench. Division bench said that no, this will
अभी
not.
और सुनते हैं, अभी और सुनते हैं नेक्स्ट वीक.
Your Lordship. Your Lordship.
देखिए, मिस आकांक्षा भारद्वाज, पिटिशनर इन पर्सन, मिस्टर सुयसधर बड़गैया, डिप्टी गवर्नमेंट एडवोकेट फॉर रेस्पोंडेंट नंबर 1, मिस्टर अमृतो दास, काउंसिल अपीयरिंग फॉर रेस्पोंडेंट नंबर 2. The argument continues. List it on 2nd of September.
Your Lordship.